tube as part of a 6-month pilot project. In accordance with Sections 45 and 53 of the Planning Act, this meeting of the Committee of Adjustments for the City of Toronto is called to order. The Committee of Adjustments considers applications for minor variances from the provisions of the zoning bylaw, permission to extend or alter lawful non-conforming uses, and consent to create new lots. To ensure a fair and timely hearing, I will vet the agenda to determine which applications can be dealt with immediately and which applications require a more in-depth review. I will call each item in the order listed on the agenda and ask if anyone other than the agent or applicant is present in interest and wishes to address the committee. If there are people in interest, the matter will be held until all non-contested applications have been cleared from the agenda. If your item is held, we strongly advise you to meet with the interested parties outside the hearing room in an effort to resolve concerns or issues. If no person is present in interest, the applicant or agent will proceed with the presentation if required. The committee may ask questions and/or take the matter into committee for a decision. When you're making your submissions, each speaker will be allowed a maximum of 5 minutes. When addressing the committee, please come forward, hand your decision request card to the committee staff seated on my right, then go to the podium, clearly state your name and your address. If you have a written submission you read from, please hand it to the Deputy Secretary Treasurer when you're done. The applicant or agent will have 5 minutes to present the merits of the application to the committee. Then individuals either in support or opposed will be allowed to express their views. If there are several speakers with the same point of view, please appoint a spokesperson. Committee members may ask questions of each speaker at the end of their submission. When all speakers are finished, the applicant will be given an opportunity to rebut only the related issues that were raised. The matter will then be taken into committee for decision. This will mark the end of all discussion. Please remember to confine your remarks to the matters outlined in the application. If you do not agree with the committee's decision, you may file an appeal. Almost all appeals are now dealt with by a new tribunal called the Toronto Local Appeal Body, or TLAB. More information about TLAB can be found on their website or on the Committee of Adjustments website. Appeal instructions will be included at the bottom of every decision. In order to receive a copy of the committee's decision and to be informed of appeal proceedings, you must fill out the decision request card, and please include your email address, as the TLAB will be sending notification and appeal updates by email. Please make sure you hand in your completed form to the Deputy Secretary Treasurer or her staff before leaving today. Decisions will be mailed within 3 business days. Are there any applicants here who wish to withdraw their application? Okay, I'm going to vet the list. Number 21. Pardon?
Conflicts or no? Doing that after?
Yeah, conflicts. Is there any conflicts?
Yes, I have a conflict in item number 27. It's in relation to a business matter I'm dealing with the applicant's lawyer through my place of employment.
All right. Okay. Number 21, 125 Belsize Drive. Applicant? Yes. Any opposition? Okay. Number 22, 186 McPherson Avenue. Applicant? Any opposition? Number 23, 17 Chester Hill Road. Applicant? Any opposition? 24, 36 Hazelton Avenue, 5B. Yes. Any opposition? 25, 332 Delaware Avenue. Any opposition? Number 26, 333 Wellesley Street East. Yes. Any opposition? No. 27, 226 St. George Street. Applicant? Yes. Any opposition?
Yes.
Oh, okay. Is this going to be a deferral?
This is, we will be opposing deferral request, but I actually understand that the councilor's office is sending somebody.
Okay. Perhaps you could advise us when that person arrives? Pardon?
Since I have a conflict,
He's
should I
here.
leave?
He's here from the councilor's office. The councilor's.
Oh, you're here? Okay, all right, let me vet the rest of the list and then we'll call you. So I think you're okay, Lisa. Just for
Just declared a conflict, so
All
I'll
right.
go for that.
So, all right, 28, 935 Dovercourt Road. Applicant, agent, any opposition? Number 30, 210 Rose Park Drive. Applicant? Yes, any opposition? Yes, all right. We'll,
29?
yeah.
29.
Oh, okay. All right, we're going to hold that one. Mind you, it's the last on the list anyhow. All right, 29, 1540 King Street West.
Here.
Okay, any opposition? No. Okay. All right, number 27.
Declared a conflict, so.
Are there any other held items?
27 and 30. 30,
Yeah.
did you hold 30?
Yeah.
Yes.
Yes.
30 was held. And 27.
Sorry, Mr. Chairman, members of the committee. I actually missed the the instruction. I was just speaking to the counselor's assistant there.
Could we have your name, sir?
It's David Tang. I am the solicitor for the Archdiocese of Toronto, the owner of the property.
So you are opposing the deferral?
I am opposing the deferral.
Perhaps we have a letter from the counselor, so we know his position. Perhaps you could tell us why you're opposing it?
Certainly. Through you, Mr. Chair, this application was filed in January of this year. So we have had about six months now of notice. My client actually has had an opportunity to meet with the condominium corporation and its representatives through its board of directors. And I will be presenting a settlement today, which resolves, we believe, the primary, or really the only, significant issues with respect to the minor variances being sought, which
You
really
say
deal...
it's a settlement, you mean something that you reached with the condominium people?
Correct, correct. So I don't know, because I haven't had a chance to speak to the lady who stood up and indicated she did object to the application. I would be pleased at this point, perhaps, and to go speak with her again and see if there's an opportunity to satisfy her concerns. I know the board has looked at it. I don't know if she has, but I'm happy to spend that time to explain how we've dealt with the impacts that might be perceived to be coming out of these variances.
Apparently, if the counselor's sending us a letter requesting a deferral, I suppose that some of the residents in the area don't believe that a settlement has been made, or they're not.
Chair, just point out in Councillor Cressy's letter, he says at the bottom, I'm writing to respectfully request a deferral of this application unless an agreement between concerned neighbors and the applicant can be reached today. So.
Okay, so Mr. Tang, we'll hold this down.
Okay, thank you.
And you and this lady and this gentleman from Mr. Cressy's office can discuss the matter.
Thank you.
Okay, number 21, 125 Belsize Drive. She's going to get these. Purpose of this application is to alter the existing two-story detached dwelling by enclosing a portion of the existing covered porch. And the material we have is material submitted by the applicant and 4 form letters in support.
Good afternoon, Mr. Chair, members of the committee. My name is David Smith. I'm here representing the homeowner at 125 Belsize Drive. Before you...
Unless there are any questions or anyone has any concerns, I'm prepared to move approval of this application.
Would you like a presentation?
Well, let me consult with my colleagues. Does anyone require a presentation or have questions?
Just have a question as to how you're going from 0.6 times the area of the lot for FSI and you're going to 1.645. So I'd like to know what you're currently at before this proposed third-story rear addition. You must be already well over.
Yes. So on our site plan, we have all of our calculations. So we are currently at 126.78 square meters, which is 1.41.
Okay, thank you.
Any further questions?
I just want to look at the site plan for a second. No, just going over so I guess that's an existing. Some of these are existing conditions, clearly, like the rear yard
Yeah.
setback is one of the existing
Yeah,
conditions.
many of the eave setbacks, the inlines,
Yeah.
yes.
Okay. I don't have any other questions.
Directly over the existing footprint.
Any conditions on this?
Has this been done on any other?
Yeah, so directly
in that row?
Yeah, so directly next door is a very similar addition, and I have a photo of it. In fact, it's even larger expansion where they've cantilevered over. That's actually one of the technical variances where we have a 1.08 side yard setback, and that's really the relationship to the neighboring house to us. So it's actually an existing relationship, but except extended now to the third floor.
Okay. Yeah, this picture on the overhead, if you have it.
Sure. So our proposal is on the right-hand side. You can see the left-hand house has also built over their footprint and extended even further. Yes, so we are not proposing the cantilever. It's just an inline addition at the third floor. And part of that inflated GFA value is because when you look at the survey, that rear laneway is actually skewed. So the first 15 or so houses have a much shorter property size in comparison to the rest. However, all the houses have a similar built form across the whole street.
I see that, yeah.
Any questions, anybody? No, that was, you've clarified everything that was sort of a question in my mind. So based on the explanation and the fact that this is going to in fact match what's going on beside it, I think this is appropriate development and meets the four tests under the Planning Act for a variance. So my motion is for approval of the application.
All in favor? You have your approval, sir. Thank you.
Thank you.
Number 23, 17 Chester Hill Road. Purpose of this application is to construct a new detached garage on the rear portion of the subject property, which is not directly adjacent to the main dwelling lot. Access to the detached garage is by way of an easement that runs along the west limit of the property, known municipally as 19 Chester Hill Road. We have before us in this application material submitted by the applicant, support from 23 Chester Hill, in opposition from 1921 and 23. 23 is on both sides of the picture. Okay, so your name, sir?
My name's Osrin Stambuk. I'm the agent of the owner.
Okay. So we received a letter, we received a letter indicating that from 2017, I believe, that this person had no objection to the garage being rebuilt, and now this person and other owners of the properties 19, 21, and 23 say that the driveway is not wide enough to drive a car to the proposed building. What is it your client proposes to do? Use it as a garage?
Yes, so right now, what's really important is what's already there. There's a completely collapsed garage that's kind of a nuisance to neighborhood, full of raccoons and an eyesore. So basically, proposal here is to rebuild it on this small, strange plot of land that's not directly attached. So basically what we're proposing to do is to just build a new garage where this existing one is that's completely collapsed. And you have those images of the that I can also put up on the overhead if you like, of the collapsed garage in the back.
Oh, we've seen those. And you're going to build this the same size as the...
It's actually going to be a little bit smaller, just so that's why you actually don't see any side yard setbacks. The eaves are going to be on the property line, but that's to prevent from ice and snow, damaging foundation. So it's actually going to be a little bit smaller, but yes, basically the same thing.
So did you agree that you can't get a car down the right of way?
Okay, so that's a bit of a separate issue. First of all, it can be used for bicycles and motorcycle storage easily. But the reason it cannot be, a car potentially cannot come down the driveway is because there are various impingements created by those people who complained about it that they're not allowed to make, like air conditioners, they have boats parked in there, fences built in the wrong place. And we don't want to stir the hornet's nest. That's been existing condition. People have gotten along. But if you'll notice, actually, this morning another letter came in that withdrew, again, opposition to, it was on the application, I saw it this morning, that withdrew opposition to the case, and that came to an understanding with the owner, who's here also.
Yeah, they say in the letter, we've had a few discussions with Mr. Vietz and the owner, work something out. That should have happened from the start, so.
Yeah.
We see also you have a letter from a lawyer in 2016 confirming that the surveyor's report further confirmed that the parcel was not landlocked and you had the right-of-way for access to the property.
Yeah. So I mean, all opposition from neighbors here is completely untenable. Like, they're creating the situation that they're complaining about. But they've withdrawn that in light of the fact that it doesn't make any sense. And so really what we're just proposing to do is to rebuild the structure that's, and have it used as a garage.
So with respect to your application, we, as a committee, cannot concern ourselves with the legal issues as to whether they built on or are obstructing your right-of-way, and they're right to do that. So are there any further questions with respect to the variances? Since there's no opposition at this point?
There's no opposition in the letters?
No, the only withdrew their opposition.
But only one person withdrew their opposition.
There was other.
That's right.
Oh, she said.
Theo McLaren.
What address is?
Theo McLaren.
We would like to, we had a few discussions. We will not be objecting. So is she writing on behalf of everybody?
I believe so. I believe that those three addresses are kind of, there's two people involved who originally had that lawyer's letter saying they will move things out of the way for use of the driveway. Then when this application came up, they were against it for a moment, and now another letter saying they're okay with it. So
even if they're still opposed, they're not here, and I don't think they have any right to object to these. If the driveway is not wide enough, that's something you have to work out between your lawyers or without lawyers.
Just so I'm satisfied with who's withdrawn what objection, it says here, we've had a few discussions with Mr. Vieth and the owner of number 17 and have worked something out. So can you clarify where Mr. McLaren resides and where Mr. Vieth resides? I'm sure we have correspondence from them, but can you?
Sure. So Mr. Vieth
is he here?
Part of Ontario Ltd, owner of the subject property.
Oh, okay. He's the landowner.
And he's right
of
here.
Number 17.
Yeah.
Okay.
And the letter of objection comes from what's their address? Number 19.
Yeah, there's a letter here from Jill Bethune-Williams, and it says co-owner of 19, 21, and 23.
Yeah.
So they own 3 properties?
Yes, I don't understand that quite well, but there are 2 owners of those properties, yeah. So it's not like as if there are 3 separate single families opposing to this.
Well, I think we needn't concern ourselves with that. The variances are what we need to concern ourselves.
Yes.
So,
yeah, Mr. Vieth wrote, yeah.
Right, so are there any further questions with respect to variances? Do we have a motion?
Just point out, Mr. Vieth, it looks like, is at 27 Chester Hill.
Both. So
he owns also,
yes.
Everyone there owns more than one property.
So he owns 27 and also owns his property.
Yes.
As part of the company.
Co-joint with, with Marianne, who is the partial owner.
Right. Any idea how long the garage has been on that property? Obviously a while, since it looks like it's in pretty rough shape.
Very long time, right, Reinhold?
No, it's original 1920s.
Okay, so this isn't like a legal non-conforming, you're not going for
No.
legal non-conforming?
No.
It's replacing a structure.
Okay, I don't have any questions.
It sounds like the original objection wasn't so much an objection as a statement of understanding that these people could park cars and boats and whatever else we wish to on the right-of-way, but that if access to the right-of-way was needed, they'd move them. That's sort of what the letter says. It doesn't say they're objecting to anything.
That was that letter came a while ago. And wasn't actually part of this application. We submitted it as evidence saying.
So then is there another one where they object again? I'm confused. And then.
Yeah, here, Carl.
I don't have that one.
They don't object to the variances, they just say the driveway's not wide enough for a car to pass through. But that's apparently because they built fences on the right-of-way, etc.
And it says we're not opposed if the intended use is for a one-story shed.
It says here, the owners of 19 demolished their garage and erected a 2-room building. Picture at bottom here. Sort of hard to see that.
Where's that?
Is this one of the things that's impinging on the ability to drive a car, this 2-room building they built?
It's partially on this subject property,
have to
actually,
work that out.
as per the survey. But again, something that will be worked out outside of.
Okay.
Yeah.
Okay. Anybody have any questions?
No.
Okay, I'm going to bring forward a motion if nobody has any questions. I would like to bring forward a motion for approval. I think some of the issues that have been raised by the neighbors are things that are out of our capacity or power to deal with in terms of the right-of-way. And also, this isn't, you're not claiming this is a legal non-conforming use, but it sounds like an existing garage, has in fact been there for quite some time, and you're simply looking to replace something that's already there. So my motion on that basis, I don't think this will be any more of an impact than it already is existing. So my motion is for approval.
I'll second that.
All in favor? You have your approval, thank you.
Thank you.
Number 24, 36 Hazelton Avenue, Unit 5B. The purpose of this application is to construct a pergola on the terrace of 5B on the 5th floor. We have before us materials submitted by the applicant, correspondence from Planning and Heritage, and 2 form letters in support. Mr. Starkey? Yes. So can we have a motion for?
Yes, Mr. Chairman, I'd like to recommend that we approve, or I'd like to move a motion to approve the application. It's identical to the one we approved this morning, and I believe that it consistently meets the 4 tests for variance and is minor in nature.
I'll second it.
All right, all in favor? You have your approval, sir. Thank you.
Thank you so much.
Number 25, 332 Delaware Avenue. Purpose of this application is to alter the existing 2.5-story semi-detached dwelling containing 2 dwelling units by adding a 3rd dwelling unit. We have before us in this application material submitted by the applicant, 2 form letters in support. Your name, sir?
Yes, my name is Peter Chi, C-H-E-E.
Yes.
I'm the agent for Danny Ciccarillo, the owner of the subject property. Sorry. In brief, the application is to regularize the existing structures, which has been existing since 1970. What these are is the, I don't know whether you have the picture there, I sent it in. It's the addition on the side.
Could you put it on the overhead, please? Thank you.
One of the other applications, the third one, the semi is a variance.
There is an existing one meet the zoning bylaw. So what we're looking at is because of the enclosed structure increases the square footage of the existing dwelling beyond the 0.6 allowable under the new building zoning bylaw, and the staircase going down to the basement, according to the zoning bylaw, we require 0.62 feet separation from the lot line, and it was built with 0.31 foot away from the lot line. The persons that were really impacted are the two neighbors to the south and to the north, because there's no changes in the front. The front facade, nothing changes. Have signed a letter in support of the applications, and this is really a minor situation, and actually it enables the creation of a third rental unit, which would meet all the criteria of the building code, zoning bylaw after this is done, and it's something that is necessary in the...
I have a question.
Sure.
So is the third unit already in existence then, or?
No, no,
Is that
no.
why you're here? I'm assuming, like, if this has been here since the 70s.
Yeah, well, no, the third, in order to get into the third unit, they need the staircase to go down to the
It's
basement.
existing, so.
No, it hasn't, well, it was there, but it was not legal.
So they can, okay. I'm just wondering how you
So
got here.
everything, as I understand what you said, everything is in existence since about 1970.
Yes.
But you now want to add a third dwelling unit.
Right.
A semi. I have a question, because we have another application this afternoon, item number 30,
Right.
where they're looking to add a secondary suite to a detached house, and that's a variance, having two secondary suites.
Right.
So I don't see that as a variance in yours, so it's
Well,
part of is there exemption for that?
no, actually, the zoning bylaw,
The third dwelling unit is not a variance.
the third dwelling unit is not a variance. The reason why, I just got this memo from the building department this afternoon. It just came into my office at 12:14. And unfortunately, I couldn't send it to the committee in time, but I have a couple copies here to give to you.
So perhaps I get maybe just the difference is that this is in Trinity Spadina, and the other one, item number 30, is in Toronto Centre, Rosedale.
Right.
Maybe different.
Yeah, this is a different area. The zoning bylaw actually allows for the third unit, right? So that's not going to be the issue. Really, the issue is really, do we pour a additional 12 inches of concrete along the side of the stairs to make the staircase a little bit narrower, right? And still meet the building code, because we double check that, or leave it the way it is, because it doesn't bother anybody right now, because the person that would be most impacted would be the person to the north, and he already consented to it. And the other thing is that because of that illegal one-story addition, which my client had nothing to do with, and when he bought the property last year, he thought everything was legal. And until we were going through the building permit process, then we found out that, nobody applied for a building permit for it.
So building permit process for other work that's being done inside or something?
No, nothing to do with it. I'm talking about the one-story addition,
Yes.
right, and the staircase.
Yes, it's already in existence.
It's already in existence, but nobody applied for building.
Your client found out it was not legal based on
Yeah.
applying for a building permit for something else?
Yeah, applying for this, for the units, yeah.
Yeah, okay.
Right.
All right.
What does that notice say?
Oh, I have another set here.
It's okay, we can, are you done looking at it?
You have to excuse me, I tend to recycle my papers,
That's okay.
right?
You said that the stairway to the basement is undersized.
No, it's actually not, the setback is undersized. The zoning bylaw requires 0.6 setback for the exterior staircase,
So he's got a
You're-
point three.
You're 0.3.
and I'm
You'd have to
0.3.
slice some off
No.
of the stair itself if you were...
Or pour another 12 inches of concrete beside it.
Like, no,
So
I
Okay.
don't understand
this,
that.
what you've given us this sheet is building permit issuance pending.
Right, except for the payments.
You have to make, so you have a development charge for this semi for $43,000?
Well, we haven't paid, we just got it today.
Okay.
So what it is once we pay these fees, the permit's issued. Those are the only conditions upon the issuance. So there's no issue with the zoning, there's no issue with the building code.
Okay, I'm just-
The only issue is these variances.
Yes, and if this application does fail, which for whatever reason, then my client would have to open the windows, open the existing structure, put openings in there, so it would not be deemed to be outside interior space, and pour a 1-foot piece of concrete along the side of the stairs. And this is the
What's the difference between the 0.6 times the gross floor area of 0.6, which the Viola requires, and you're at 1.07? That's because of the illegal addition at the back.
That's because once you get into the legal addition, then everything gets recalculated.
Okay, and
because,
then you include the basement.
and you have to, yeah, exactly. Because most of this building was done prior to the zoning bylaw being in existence, even the 1986 one.
Got it. Thanks.
Right. Do we have a motion?
Any conditions on this one?
No.
Conditions, okay. Thank you for all the clarification, that really
Yeah,
helped. in terms
you're welcome.
of The questions I had in my mind.
No.
So on that basis, given that the addition has been existing for some time, we have no complaints or letters of objection from neighbors. We can see, in my view, this has little to no impact probably on the existing neighborhood. And on that basis, in my view, this would meet the 4 tests under the Planning Act for a minor variance, and my motion is for approval of the application.
Seconder?
One second.
Thank you.
Favor?
Thank you.
Have your approval, sir.
Thank you.
Would you like the paper back?
Oh,
Yes. I don't think we need
Anybody
that.
want to look
Since he
at it?
recycles it.
No.
Oh, we're okay, I think we're good.
You could
right?
take it,
Did you want to have
please.
it, do you want to have it?
No, I don't think
not
it's
relevant.
important. It's not relevant. All right, 20,
Yes.
number 26333 Wellesley Street East. The purpose of this application is to alter the existing 2.5-story detached dwelling by constructing a rear 1- and 2-story additions over the existing dwelling and a rear 3-story addition with decks on the 1st and 3rd stories. And we have before us in this application material submitted by the applicant and correspondence in concern from 34 Amelia and 335 Wellesley Street. Your name?
My name is Margaret Roman. I'm the acting agent on behalf of the owner, property owner.
Can I ask a question right from?
Sure.
You refer to drawing Z1. It appears on that drawing that on the east side, there's a walkway or a space along the whole east side of the building.
That's correct.
And then when you look at the drawings A2, A4, it appears that the building actually goes from lot line to lot line. And I'm having trouble
Oh, here it is.
making sense of, because the application is all at the back, what happened to the sliver of land along the east side?
The lot line is actually on an angle, and it reduces from the front to the back, but are you specifically referring to the dimensions based on the pavement in the back of the property? I'm sorry.
I'm referring to which is the zoning plan, which is the only site plan that we've got.
Okay.
See. And on that plan, there appears to be a space, a setback along the entire east lot line
For the existing house.
for the existing house. But then all the other drawings indicate that the house goes from property line to property line. Is this drawing wrong, or are you?
The drawing is, the zoning drawing is correct. It's based on the survey, the recent survey.
This is showing as open space. But then when, in all of the drawings of the proposal, you go from property line to property line. You go from there to the property line. So what's happening here?
This remains as is. The actual building continues from the existing concept of the
So
This is
So that sliver of land along the east side is still there? Yes. And it's really hard to tell with the drawings, because there isn't a site plan. So, in fact, there is in fact an east side yard setback.
Nothing has been changed with the east setback. The property line continues as it is existing.
Yeah, but it's not here though. It's up here somewhere. There's space between the building and the property line. So the property line's out here somewhere.
So are the floor plans wrong?
Okay. No, the property lines, it doesn't actually go from property line to property line. There is a side yard setback.
It doesn't look like it on the floor
No, it doesn't.
We're talking about
Okay.
the east side.
Yeah, yeah.
The west side, there's a variance.
It's very confusing. Okay, thanks.
The only other thing I noticed is that the property's been designated. We don't have any comments from Heritage on this? Any comments from Heritage? Anybody? No? Okay. It's everything at the door, I guess.
I do note that we have two letters of concern, but they both relate to construction-related activities.
Okay.
It was actually a very good letter by the Campbells, just relating that, but we can't, there's no issue about keeping the number of construction activities down. We don't deal with that, and that's
Okay.
just a result in a rapidly changing city.
All exit and entry to the property would be through the rear, the back alley entrance, which is behind Wellesley.
We don't deal with construction.
And there's a third-floor balcony that it overlooks the rear yard and then the lane, so it doesn't really appear to impact adjacent neighbors that much.
Are there any further questions, or can we have a motion?
Oh, here we go. Oh, it's all at the bottom.
Yeah.
Okay. So in terms of the three-story addition at the back, is it accurate to say that it's about the same depth as adjacent properties? It looks like it based on your zoning plan.
It is almost exactly the same as the property, Lot 46, if you're looking
Right.
at the,
And that's a 2.5-story house?
31.
yeah. Mm-hmm.
Okay,
At number 331,
yes.
the house to the
And
west.
335 is 1.5-story. And have there been any discussions with the neighbors about the proposal?
Not that I'm aware of, to be honest. They do have an amicable relationship between both property owners. The Committee of Adjustment application is in the window, so I think if there was any specific concern, they would address it or be present at this hearing.
I don't understand that.
It's a detached house.
Yeah.
Look at the survey, Lisa. Detached house on the other side.
Oh, I see. The number 335 is right up to the property line.
Yep.
That's why it looks it's confusing. Okay. Is there-
Anyway, if there's no other questions, I think I'm ready to bring a motion to approve the application, and I don't believe there's any conditions.
Seconder? All in favor? You have your approval. Thank you.
Thank you very much.
Number 28, 935 Dover Court Road. Purpose of this application is to alter the existing two-story duplex by constructing a third-story addition with new rear second and third floor balconies. Additional alterations include the construction of a rear ground floor walkout and deck. We have before us in this application material supplied by the applicant and 10 form letters in support. Yes, sir.
Yes, good afternoon. My name is Leo Mastandre. I'm the agent for the owners at 935 Dovercourt. In addition, this morning we received the letter of support from the neighbor to the north, who's most impacted. And we have one copy. We spoke to the neighbor on the south, and they did not have any concerns.
So let me just read this in the record. We have a letter of support from 937 Dovercourt, signed June 13th.
And we spoke to the neighbors to the south, and they had no concerns. The planning staff had no concerns regarding this application. We have a total of 11 variances, of which 5 are existing conditions. In the new bylaw, number 2 and number 4 are existing conditions. And in the old bylaw, number 2, 3, and 4 are existing conditions as well. The variances, all other variances are minor in nature and similar to the built form and consistent with what's been approved here at the committee. I do have some photos with similar proposals. In the area. As well as I also have similar decisions which also have been approved. I think our variances are appropriate for the neighborhood, and I feel they're all minor in nature. If you have any questions.
Mr. Musselman, what's the existing FSI?
Well, we have a
One
current
times coverage to 1.22, so do you know what it is now prior to the
yes.
those renovations?
Yes, I have existing permits here. And at 0.89, the existing.
What about number 6 under the old bylaw? May not exceed 0.15 times the area of the lot, and you're asking for 0.40.
11.
Is that correct?
Yes, that is correct. I'm not sure how that applies. I think it's when you're adding a second suite, I believe.
So the height variance is from 9.5 to 11.1. So you showed us this picture at 973 Dovercourt, not too far away.
Can I just show you on the overhead what they're speaking of?
Yep.
So they're speaking of you see the highlighted in the green? That's the variance. It's just because of the main wall. But if you look on the side elevation, that's at 10 meters. So basically, it's because of the main wall. The wall is gable at the front is the reason why that applies. But the overall height is 12 meters, which we don't have a variance in the old bylaw. And in the new bylaw as well, the overall height is at 12 meters, which we are under.
Can you put the first elevation up, please, that you just showed?
So the 10 meters is to the, we have 10 meters to the eave. That is, that point there, that's 10 meters.
Which one are you looking at?
This one.
Yeah.
Oh, yeah.
Well, that was approved by, not by our committee. That looks awful old.
Wow.
Questions?
So that balcony on the current house above the sort of porticos, that is coming down. Is you're going to be building, or are you going to have another little smaller balcony there?
On the third floor? Or?
On the second floor.
On the second floor, that's existing.
Existing. Okay. Oh yeah, I can see. There's a door there and a. Yeah.
Pardon?
It's remaining that size?
Yes, correct.
And that didn't trigger a variance because it looks like it's an oversized board.
Well, we submitted for zoning review, so no.
And you have a letter of support from the property on
To the north.
number 933?
930, the one to the south?
Yeah.
We have a verbal support. They have no concerns. 937 to the north, we just submitted.
The one I was more concerned with 933 because you've got a third floor balcony on the side of your house.
We spoke to them.
Overlooks their property. They
Yes.
don't have a problem with that?
No, they have no concerns.
Any further questions, or can we have a motion?
It's really not part of your variance, but I would hate to see you back here approved with this as a precedent, the balcony on the third floor on the side, because that is, in my view, very intrusive to the adjacent property owner. If they don't have concern with it, then who am I to object? But I don't see this as a precedent for doing that again. I think that that's a hardship for the property owner to the south.
The third floor rear balcony?
No, the balcony on the side.
What drawing is
There's one on
that?
the rear,
It's,
too.
There's one on the
the
second
one on the
floor.
rear is A40. The one on the rear doesn't bother me as much as, because the one on the side's right adjacent to their house,
Is that the front?
front corner.
Oh, yeah, I see.
You see it? I wouldn't want that to be considered a precedent, because I would.
Yeah, it's a balcony off to the side there.
I wouldn't want to recommend that on another property. Is that balcony important to you for the development of the house?
Not necessarily. If you would like to, like I said, we did speak to both neighbors and they didn't have any concerns, but if it helps approve the application, we could remove it.
I think it's a dangerous precedent.
And that's on the third floor, yeah.
It's on the third floor on the south.
Carl, could you make a motion asking for that to be removed?
Would you like to volunteer to remove, or do you want me to make a recommendation that you take it off? Because I'd like it gone.
Okay, then let's remove it.
Okay. Mr. Chairman, I would like to recommend approval of this application. I think it meets the test for variance, and I think for the most part it's reasonable development. I do have concerns with the third floor south balcony, and my approval would be conditional upon that balcony being removed from the proposal.
You have a seconder?
I'll second that.
All right, all in favor? Have your approval, sir.
Thank you very much. Have a nice day.
Condition is that?
Removal of the third floor balcony on the south side. Side.
Number 29, 1540 King Street West. The purpose of this application is to alter the existing two-story, 5-unit residential building by creating 3 additional dwelling units in the basement for a total of 8 dwelling units. The basement dwelling units will be accessed through new front and rear sunken walkout entrances. The rear attached garage will be replaced by surface parking. In this application, we have before us material submitted by the applicant, a report from engineering and urban forestry, and four form letters in support. Your name, sir?
My name is Roman Tsap. I'm agent for the owner of the property.
How many do you have? 5 units. But what's in the basement now?
It's one large unit.
Okay, so
A dwelling unit?
Yes.
you're adding 3 additional ones, and there's going to be 4 in the basement?
Yes, it's just going to be divided into 4 equal, or as equal as we could get them.
The other 4 are?
They run lengthwise on either, or down the middle of the building.
2 on the first floor, 2 on the...
Correct, yes.
Can you run through the variances on what the existing conditions are? Because the numbers, I think, are misleading. They're very large, but your existing conditions are probably greater than the bylaw allows at the present time.
Yes. Is there a particular one that you wanted me to address?
Are these essentially all existing because you're doing all the work in the basement? I mean, you're doing all the work inside, is that right?
For the most part, we do have to construct the patios or the walkouts to access the basement. And we are, a few of the variances are being improved upon, in particular the building length, because the existing garage is attached to the structure. And we are improving the rear yard setback as well, because the garage is pretty much built out to the lot line.
So 1 and 2 are existing conditions, right?
The building depth, yes, and the variance, yes.
Okay, the rear yard setback, 3, is that existing?
Yes, currently it's 0.4 meters. We're improving that to 6.65, which is measured to the attached garbage enclosure and not the rear main wall of the building.
Okay, the landscaping is...
It's a slight improvement, or a slight difference from the existing condition, about 3%.
So the depth is existing?
It's existing, but it's being improved upon.
Right. Have the floor space is just be, what, you know what it is now, and is it now the basement counting where it previously didn't count?
Given that the finished elevation of the ground floor, or sorry, of the basement is closer to established grade than the ground floor, they do count it towards the gross floor area. Right now, I believe we have 1,300 and change, which represents a floor space index of 2.09, and we're proposing 2.11. Okay. We're consolidating a couple of the mechanical rooms, which essentially is that discrepancy from 2.11 to 2.09. But nominally, there is no change to the floor area.
In terms of the sunken walkouts, both at the front and the rear, are there any variances triggered by that?
Not that I am aware of, no. For the most part, it is hardscaping that's existing now.
Right.
So it doesn't really change the
Doesn't contribute to the depth of the building or anything like that? Just, no?
No, they don't count it as part of the depth, no.
From your plan A000, it looks like these basement units are not, they're pretty high out of the ground. Looks like you have generous windows on those units.
Yes,
it's all subterranean.
No.
Mr. Clark, we have a hearing impaired person here who would like everybody to speak into the microphone. I don't think is yours on?
Yes.
Oh, it is.
It is.
Perhaps you could speak into it more directly, so.
So I was just pointing out that the basement units, first of all, they're not.
Have them within the interior of the building, but we do provide an enclosure at the rear. Given that it's not a typical apartment building where you have a common corridor that you could provide a centralized bicycle room, because there's 2 or 3 different access points, we felt it would just be easier to provide it in an enclosure.
Okay. But there's no variance with respect to bicycle spaces outside the building?
I believe there was one regarding we are supposed to provide a short-term visitor space, but they will be consolidated and used as needed.
Oh, right.
Can you clarify for me under 7 under the old bylaw, is a parking station, does that mean a parking space?
I believe it's a group of 5 or more parking spaces, or 4 or more, if I remember correctly. That's how they define it, yeah.
Thanks.
Do we have any further questions? Do we have a motion?
would like to point out that we are consistent with the OPA policy 3212, which is that the city will encourage older apartment buildings such as these to be renovated and replenished. Additionally, a lot of for the majority of the buildings along King Street that are adjacent or across the street from Beatty Boulevard Park are these older estate-style dwellings that have been renovated into multiple dwelling units. We're not out of character for what is existing.
Mr. Chairman, unless there are other questions from my colleagues, I'd like to move approval of the application. It's refreshing to see buildings of this caliber and quality retained in the housing stock of the city. This is one of the more comprehensive submissions I've ever seen in my time, and my compliments to you for that. I think that this clearly meets the intent and purpose of the official plan and the bylaw. It expands our housing accommodation in a particularly neighborhood-friendly fashion, so I'm pleased to move approval of the application.
Do we have a seconder?
Oh, and subject to forestry condition number 1, pardon me.
I'll second your motion.
All in favor? You have your approval, sir.
Thank you.
Okay.
Back.
Number 27, 226 St. George Street.
Is something we said?
Yes? I said 220.
Afternoon again.
I'm not sure I read the purpose of the application into the record, so I'll do that now. To replace the demolished rear addition with a new 4-story, 27-room rear addition for the purpose of religious education, use, and religious residence. Note there is a concurrent site plan application, and we have before us in this application material submitted by the applicant, a report from Heritage Preservation, correspondence in concern from Unit 10, 228 St. George, and correspondence in opposition from numerous people living at 228 St. George Street.
Mr. Chang, is there still someone with you on this application, the councillor's assistant, any other area residents from the Condo Corp?
In opposition?
They are here. We have met outside with them.
Up to the front of the room?
Come up to sit in this row, please.
And is Mr. Cressy's executive assistant still here?
He's here.
Yes, he is. So I'm pleased to advise that we spent some time outside, and we've
Please
had
sit in this row here.
And we've had some success in terms of explaining the application and providing some additional information so that the various residents who were not part of the actual negotiations with the Condominium Corporation Board are able to understand what is being proposed as changes and commitments to the Condominium Corporation. So I believe we do now have agreement that this matter can proceed on that basis. And as a result, I believe Councillor Cressy's office is prepared to withdraw, if necessary, the request for the deferral.
Just to be clear, you had an agreement with the board, the condo board?
Correct.
But then you had all the individual unit holders who were raising objections?
Well, I believe we had two ladies, actually, it turns out, who were here, who were not part of the board, who wanted to understand what was going on. And we've spent the time profitably outside doing that, helping them understand what was being proposed to address some of the condominium board and 228 St. George concerns with respect to the variances. And it's really just the one variance that is providing the primary concern, and I can walk you through that if...
So are you making changes to variance number 5?
No. So what we've done is we've designed around the problem, which is really primarily shadow and overlook. And I do have minutes of settlement which have been signed, which I'd be pleased to pass up if I... Just need to keep one copy here, but If I might, I'll pass up copies of the some visuals as well.
Thank you.
Can you clarify for me, the condominium board as a unit objected originally. Now, is that correct or not?
No, I
There's a
believe...
number of individual objections. Did the board file an objection as the board?
Yes, I believe so.
Have they withdrawn that?
They are here with these minutes of settlement, which I'd like to walk you through, perhaps, and you will...
And these minutes of settlement satisfy the board?
Yes.
Thank you.
Okay. I don't know if the committee spent a great deal of time looking at the application and whether you would like me to go directly to the resolution of the concerns. This is really the north setback, side yard setback that we're dealing with is the only one that's really contentious here. And
10 feet?
3.06 meters on the north side, whereas 7.5 is...
That's right. That's the one.
Variance 5, and then under the old bylaw, I believe it's variance number 2.
And there really wasn't any other concern, not setback.
Right.
That was...
Condominium corporations, lands was the major concern that I read.
Correct.
Okay.
Correct. Okay. So if I can perhaps, let me just show you what it looks like, and then I'll explain to you what the resolution is. The best place probably to see that, obviously, is in the document book, is to turn to page, I believe it's 7. Sorry, not 7. Five. And you'll see that really...
Page 7
Page
or page
5. And so it's the condition at the rear or the left of the property, and you can see that the architects marked the required 7.5 meter setback in a blue dotted line. And of course, what's happening is that portion of the pink building, the salmon colored building, is closer to the property line, and that's the variance that we're dealing with. And what it looks like, effectively, as originally proposed, is a 4-story building running straight up. Okay? And if you look at the minutes of settlement, what the applicant has agreed to do, top floor would be stepped back to effectively where the old building used to be. Okay? Secondly, that addresses the shadow issue. Secondly, the Archdiocese agrees that the windows facing north, in other words, towards the condominium buildings, will be translucently glazed, except for the easternmost, or towards St. George, 0.5 meters. Okay, so that effectively satisfies the overlook or privacy issue. Okay, there are some other provisions in here relating to doing pre and post construction surveys, and we've agreed in paragraph 4 that we would ask you to impose as a condition of the minor variances the requirements of paragraph 1 and 2, which are the step back and translucent glazing in the building permit drawings and the site plan approval drawings. And that effectively addressed in literally a step back and through translucent glazing the primary concerns of privacy and outlook, which are the primary concerns of the condominium unit owners to the north.
Right. Can you tell us about your discussions today?
Certainly.
The individual unit holders?
Sure. So the negotiations and discussions have been carried on with representatives in the past, and they were finalized yesterday. That did not, unfortunately, give an opportunity for all of the unit owners to have an ability to understand what was being proposed and to understand the impacts of those two changes. And that's what we did outside today, is to explain and talk about what the implications of a step back would be in terms of shadowing, because it's not necessarily intuitive to understand the impacts of those, or what, in fact, a translucent window would look like. And fortunately, there are translucent windows right outside that we could refer to indicate those concerns. And so we believe the unit holders that were not, quite frankly, kept in the loop right up until the last minute have had their concerns satisfied. They've told us that. And so we would like to ask you to impose the condition that's set out in paragraph 4 of the minutes of settlement, that both the setback or the step back to 7 meters and the translucent glazing requirement would become a condition to any approval that you might deem. Glass like this. And imagine that I am inside the proposed building looking out at the condominium building across the way. St. George is here. Okay. What is being proposed is the majority of the window would be translucent glazing. Right. The last half a meter would be vision glass, would be clear glass. These are little bay windows, so they would come back along this way approximately another half a meter. So that would allow the occupants to look towards St. George, okay, but not to look directly into the windows across the way, or vice versa. It assures privacy on both parties.
Very creative solution.
Someday somebody's going to wonder, what the hell did they do that for?
How high is the condominium building? This is a 4-story addition you're doing, 4-story. How high is the condo at MTCC 1140?
It's 4
4
floors.
floors also.
There's stacked townhouses.
Right. Okay.
All right. Thank you, Mr. Tank. Perhaps we could have a representative of the opponents to come and verify, confirm what you've said. Not that I don't believe you, but we need it for the record.
Can I read this? I didn't get one of those.
Yeah.
My name's Carolyn Pahora, and I live at 228 St. George Street. I'm a part of the board of directors, and I'm also an individual owner. And we had a very long discussion out in the hallway about the windows and about the issues that I had raised in my letter that I submitted to the committee last week. And I'm satisfied that my concerns have been addressed.
By this minutes of settlement with the board?
Correct.
Okay.
I only ask that one thing I would like to request is that the Archdiocese keep in contact with us about any future plans, because we're just hearing about this in the last couple of weeks, and we haven't had time to process what's happening. So I'd like to be kept in the loop about what's going on. I understand that perhaps you can't enforce that, but that's something I would like to see.
You personally didn't, or did the Archdiocese get in touch with the condo board? You're on the board.
I am on the board.
So you're saying the board first found out of it when they got served with the notice of the hearing today, weeks ago?
6 weeks ago.
There was no prior consultation?
There was not.
I would suggest that you make it a habit to contact Mr. Tang once every 3 months or whatever you feel, because it's not within our jurisdiction to do, but I would suggest to you that you might, if you want to be kept in the loop, you might contact Mr. Tang to find out what's happening.
Thank you.
From time to time.
This is just for a status update on whatever's happening, or if they come back for additional relief from the bylaw?
If they come back, if they require additional hearings for bylaws, and also to keep us in the loop of what's happening. For instance, when's the construction starting? We weren't kept in the loop about the demolition, and it was a surprise to us when the building was actually being demolished. And it was a very large project, and it did have a big impact on us as homeowners. So that's why I asked that we keep in the loop about.
Granted, he said we can't really impose that because
I understand.
Other than on the record today, it's obviously, and Mr. Tang is only the lawyer, but obviously he should send a message to the people doing the construction for his client that they should keep the adjacent properties informed of those issues as a good neighbor.
Thank you.
Thank you. Did anyone else not feel their view was represented here? All right, thank you. Thank you, Mr. Tang. Is there anything else you want to say?
No, I can, there was a glitch. Apparently, a letter was put in a mailbox for the adjacent property, which didn't. Anyways, that's all sort of passed at this point, and I have made the commitment to the condominium unit holders that we will remain in touch throughout the rest of this process, or my client will.
Okay.
Thank you.
Do we have subject to any further questions, do we have a motion?
Is the councillor's office satisfied with this?
You have the HPS condition as well, right?
Yeah, just submit plans. Sylvia, do you have a copy of this?
Do you need this, these original signatures, do you need these back, or?
I have a copy. I'm content to leave at least one copy with.
We just need one copy for the record, so, since this is an original.
The conditions are number 1 and 2.
Mr. Tang, you referred to it as paragraph 4. Do you want us to refer to paragraph 4 in our approval, or do you want us to refer to paragraphs 1 and 2?
Paragraphs 1 and 2 are the operative conditions. 4 says we would ask you to make 1 and 2 the conditions.
Okay, all right, so just 1 and 2 is
Yes.
what we mentioned. Okay. So we have a motion.
Mr. Chairman, I'd like to bring forth a motion of approval subject to the heritage approval, standard approval conditions about prior to issuance of a building permit, submitting the appropriate drawings to the...
Okay, I'm happy to second Mr. Nipfel's motion.
All right, all in favor? You have your approval. Thank you.
Thank you. Thank you.
I'm glad you were able to work it out.
Yep.
As we're...
Number 30, 210 Rose Park Drive. Purpose of the application is to alter the existing 2-story detached dwelling with 2 dwelling units by demolishing the rear detached garage and constructing a carport and rebuilding the front porch and 2nd-story balcony. Interior renovations will also be done to establish a 3rd dwelling unit. And we have before us material submitted by the applicant, a report, staff report from Urban Forestry, and correspondence in opposition from the Moore Park Residents Association and Susan Greer and John A.B. McDonald, 269 Heath Street East. Yes, sir.
Yes, my name is Murray Fern. I'm the agent, applicant, and designer for the owners of 210 Rose Park Drive. I just wanted to say before we start that there's been some changes to the application due to the repeal of some of the requirements under the old City of Toronto bylaw.
Well, we have items 3 and 4 under the old bylaw crossed out. Is that what you mean?
Yes, items number 3 and 4 have been deleted from that application.
We've been informed of that.
Also, too, when the zoning examiner was reviewing it, item number 8 was also removed because the calculation of ancillary buildings was, I guess, reduced when he was reviewing the application. So item number 8 was removed, and item number 5, which refers to the percentage of ancillary buildings on the property, was reduced from 75.82 meters squared to 59.29 meters squared, and that represents the percentages reduced from 14.29 to 11.20. on that same item number
What was the
5.
square meters again?
Reduced from 75.82 square meters
Two.
to 59.29 square meters.
Thank you.
Are those the only changes, sir?
Yes, sir, yes.
So I think that the opposition letters that we received dealt with third dwelling in this building, loss of rear yard, soft landscape. Could you address those, particularly the issue about a third dwelling unit?
Yeah, that seems to be the issue here before the committee today. Just let me sort of go back and say that our the owners purchased the house in 2013. At that time, there was 3 units in the existing property when they purchased it, and when they had spoken to the owners there, they said it was at least 5 years prior to them purchasing it that it's been in 3 units. So they have been there sort of off and on for the last 10 years. When the basement apartment was vacated approximately 2 years ago, the basement tenant moved out. The owner sort of started this procedure to revise the basement apartment so it was compatible with the building code requirements, also to legalize it, which we've come today to the Committee of Adjustment to do that. The owners have spoken personally to their adjacent neighbors at 2008 and 2012. Unfortunately, they didn't write anything down specifically, but they have no opposition to the application. And I spoke to the planner of the area, and he also, the planning department has no official opposition to the application.
Mr. Fern, the tenant in the basement moved out 2 years ago.
Yes, approximately.
And since then?
It's been vacant.
Vacant.
Yeah.
Okay, but prior to that, there was a basement apartment?
Yes.
Okay.
How long did you say that basement apartment existed, illegally, albeit?
Yeah, for approximately 10 years, that's what my owner could determine that.
So can you tell us about the area as to whether, because it seems from your the opposition letters, there are no 3-unit dwellings in that area?
Well, it's hard to determine. Legally, you're not allowed to have 3 units, so we couldn't determine exactly if there are other properties that have that. Although the adjacent one, 2008, has 2 properties, two tenants in it.
2 tenants plus an owner, or just 2 tenants?
No, just 2 apartments.
2 dwelling units.
2 dwelling units.
1/3, yeah. So you don't have any other examples on Rose Park of other 3-unit buildings?
No, sir, no.
Okay. And what about, I just didn't know, the second-story platform is double what's permitted. That's not one of the things?
Well, the ground floor platform and the first floor, or the second floor, are both existing. What we are planning to do is square them off. They angle out on a small angle, so it would add about 7 square feet to each platform, the second floor platform and the main floor platform. It adds about 7 square feet to each of them, but we're just trying to square those off.
So the other 2 units, is there one on the first floor, one on the second, or is it?
Yes, exactly.
Okay. And this is the amenity space for the second floor unit. It's this oversized balcony.
Yep. And with regards
to any...
there was an issue with the rear yard landscaping. Well, everything is existing now. We're not proposing to reduce the landscaping at all. Unfortunately, well, most of the rear yards of our property and the adjacent property are paved due to access to the garages. Both accesses to the adjacent neighbors, the right-of-ways are on either side of our property, so the green space is is reduced quite a bit that way. But again, we're not reducing the amount of soft landscaping as that, and we're replacing. There's
So when you replace the rear detached garage and construct a carport, you're saying it's the same, it's not changing, it's not getting worse?
Yeah, the footprint is the same. I can show you sort of what it's
same rear yard soft landscaping.
Yes, yeah.
Either way.
Yes.
Mr. Fern, thank you.
Okay.
And we will call you back. We're going to hear from your opposition at this point. Thank you.
Good afternoon. My name is Jeremy Gowan, and I actually live at 238 Rose Park, which is a little bit further east of this. I'm very familiar with the neighborhood, but I also represent the Moore Park Residents Association. In fact, there are probably about 10 of these sort of houses, which some of them are divided up, down, some of them sideways, and one or two of them have been converted into a single house. I'm not aware of, this is the first I knew that there was 3 apartments in this particular building. And
the other multiple unit?
They're all either
all 2 units?
All 2.
Yeah.
Okay. And the rest of the street is single family, single detached houses.
So
there's none in 3.
None in 3.
How many houses are we talking about on Rose Park?
Of the particular variety that we're referring to here, I'm guessing about 10.
No, I mean...
For the whole street,
yeah.
Probably...
No, I'm not talking about multiple units. I'm talking about how many houses are there altogether.
Yeah, I realize.
Yeah.
There must be 50.
Yeah.
It's a longish street. Version would just simply add to them. Yes, we recognize that the province's provincial statements are for greater density in the city, and we are not against that. But the city has the right to designate where this may occur, and this area is not one of them.
How large are these houses in square feet, approximately?
Oh, they vary all over the map from probably my own house is one of the smaller ones at 2,400 square feet, up to perhaps 4,000 square feet. And it's a very wide, I mean, it's, there's no cookie cutters there. They're all very different. They're all built in the 1920s, except for 1 or 2 replacement houses.
210 Rose Park, do you know how large that is?
I don't.
One of the larger houses or one of this?
It's probably one in the middle. I'm guessing 3,000 square feet, but I really am not sure.
Interesting to point out, variance number 2 under the old bylaw provides that you can have more than 3 or more dwelling units, provided the house has a minimum residential gross floor area of 460 square meters. This is 350, so it's well under what would allow them as of right in a large house to have 3 or more dwelling units. But they're not. They're well
But the old bylaw is the old bylaw.
But it's not. The new bylaw just says you can't do it, right?
And frankly, we just don't see that this meets the 4 tests. We don't think this is a minor variance. It's in direct contravention of the zoning bylaw. And we think that the OP and the zoning bylaw designated this area as primarily single-family detached houses. Yeah. And we just don't want to see this street converted in. Frankly, it'll be a series of apartment houses if we're not careful.
Yeah, so unlike certain variances where you're looking at, you're allowed 10 meters height, you want 11, you're allowed 6.6 GFA, you're going to 0.8. This isn't a yes or no type question.
Exactly.
In this particular variance.
Exactly. And the rest of the variances, I can't say I'm happy about the backyard being paved over completely, but that's the situation, whether we like it or not.
Okay.
So that's our comments.
All right. Thank you.
Sir. Mr. Fern.
Mr. Gap.
Yes, I think, I guess in general, it looks like the previous building zoning bylaw, the old City of Toronto bylaw, is being phased out, And actually, the new bylaw allows for a secondary suite, as did the previous bylaw under certain conditions. I guess in general, as I said, this house has had 3 apartments in it for at least 10 years. There'll be no physical change to the building itself. If I know parking has come up as an issue, well, we have parking for 3 cars in the back of our property. There's an existing 2-car garage that's there, and again, the existing garage that's being demolished and replaced with a carport. It's going to provide that a 3rd parking spot again if we have the 3 units.
Parking isn't an issue. There's no variance.
No, there isn't, but I know it's come up in
Well,
conversation with
every application involves a parking problem. So, but this application is very black and white. No 3rd dwelling unit. Yes or no? So, I mean, your argument is that it's been there. Perhaps nobody knew about it, but it was there.
And again, like under the official plan, the city's calling for higher density. But again, sort of because there's no sort of physical changes to our building here, it will just be as existing as it is the same now. And the owner, as I say, he when the tenant moved out, left it empty because it didn't comply with again the zoning bylaw and the building code, and she wanted to wait till we could get approval to do.
So does the owner live on site?
No, sir, no.
Okay. All right, Mr. Fern, did you have anything further to say?
I think that's fine.
Right. Thank you very much. Unless somebody has a question.
Yeah, I'm ready to make a motion unless someone has any more questions.
Go ahead.
Unfortunately, this application, as the Chair just stated, and I said it earlier, it's sort of black and white. It's not a question of how big a variance over for height or GFA or FSI. It's either yes or no, and I think in our district, it's pretty clear that a 3rd unit is not permitted, and for that reason alone, and based on the Moore Park Ratepayers Association submissions, I would move to refuse the application.
Seconder. All in favor? Thank you. Your application is refused, sir. I now want to vet the 230 list. Number 31, 295 Ronsonsville Avenue. Applicant here? Yes. Any opposition? Yes. Could you, we're going to hold this down. Perhaps you could meet outside and see if you can resolve the issues. 32, 355 King Street West. Applicant, any opposition? Thank you. 33, 492 Eastern Avenue. Applicant? Yes. Opposition? No? Okay. 34, 28 Bathurst Street. Yes. 35.
Any opposition? No?
Yeah. Opposition?
No.
Okay. 35 Toronto East Health Network. Pardon me. 825 Coxwell Avenue. Yes. Any opposition? No. 36, 113 Borden Street. Yes. Any opposition? And 3793 Galley Avenue. Yes. Any opposition? Okay. It's not 4 o'clock yet. All right. Is anybody here from number 38, 28, and 30 Glen Manor Road? No, I know that, but they might be. All right. Okay.
I have a conflict to declare in one of the items on the 2:30 agenda. Item number 35, the Michael Garron Hospital at 825 Coxwell. I've recently had some business dealings with the contractor for this project with respect to this project, and so I'll declare a conflict.
Okay. We start with number 32, 355 King Street West. Purposes to alter the redevelopment plan approved by site-specific bylaw 1041, 2010 for the construction of 2 residential towers by reducing the number of residential parking spaces and to permit a commercial parking garage. We have before us material submitted by the applicant, Ms. Kovar. When aren't you reducing residential parking spaces?
Well, and in fact, this is the second time that I'm seeking the committee's blessing for a reduction. The committee did reduce it once for us, and I'll touch on that. So this is the King Blue project. It's a very large project at the southeast corner of King and Blue Jays Way. It's nearing completion right now. The building has been constructed with 349 parking spaces in the garage. There are 57 for visitors, 34 for the non-residential uses in the building, and that includes a hotel and a theater museum. And there's 7 car share spots and then 251 residential parking spaces. And this application concerns the residential parking spaces. When this site was zoned 15, we had sold just about 3/4 of the units in the building. We had sold 74% of the units in the building. And so what we did, we said we want to leave a buffer for the remaining unsold units. We made a guess as to how many spots we would need, and we left a buffer of 31 spaces in the building and got the approval and have gone ahead now. What's different now is the building is 100% sold. We're in the final phases of getting condominium approval. The building will be occupied the first quarter next year. We need to know for condominium registration purposes what to do with these 31 leftover spots. So the proposal now is to ask for another very minor increase or decrease from 0.3 per unit to 0.27 per unit. And that would allow us to take the 30 of the 31 leftover spots and make them available for commercial parking so they're not sitting empty. All the unit owners in the building, including those who bought bachelor units and 1-bedroom units, have all been offered parking. And as I say, the building is 100% sold. There is simply no demand for these spaces. And at 0.27 per unit, we're still providing more parking than many buildings in the King Spadina area of the city. The last application was approved and was found to be acceptable by City Transportation Services staff, and again, this time they have raised no concern with it.
Okay. Just a quick question, because you approved the 250, you're going to 222. So by my math, that's 28. You said 30. So, and I think there's a little discrepancy in your letter.
We were approved at 250, but
Yes.
we actually built 251.
Right. Okay.
So there's a discrepancy of 1 because we actually built an extra spot, and that's the spot that we're going to leave for the residential. But we'd like to transfer 30 of the 31 unsold spaces to make them available for commercial parking.
I'm having the same problem, maybe, and it's minor, but on your letter, you talk about going from 250 to 221, which is a reduction of 29 spaces. But then you talk later in the same paragraph about it being 30 spaces, and you reference at some point...
I'm reducing the requirement from 250 to 221. So the requirement is being reduced by 29, but it's actually 30 spots that we're moving over.
So in your variance request, you have...
Because we have more than required.
Okay, in the variance request, you're providing 222. Is that the difference? And that's the 1 spot?
That's the 1 spot.
And then you have your 7 car shares.
Yes, and we have the 7 car share spaces. They're not being touched. They are being retained.
Okay.
And then,
so if we approved variance, I'm afraid we're going to get a decision that doesn't work for you. If we approved variance number 1, you would end up with 222 parking spaces. That's what you want, or 221?
222 is what I want.
Okay, so that's with the extra 1 added in.
Yes, that's exactly right.
Thank you.
Yes. And then the last 2 variances are technical variances which flow from that. This building already has what we would all refer to as commercial parking. It's got 34 non-residential parking spaces in the building. And any member of the public is allowed to pull in and park in one of those spaces. But because they are required by the bylaw for the commercial uses in the building, they're not actually considered commercial parking, they're considered non-residential parking. And as such, they don't count for gross floor area. Required parking doesn't count for GFA. These commercial spaces that I'm asking you to approve are actually a new use, if you will. They're not required by the bylaw, they're leftover spaces. So since they're not required, they're considered a principal use on the lot, and as such, they count for GFA. So that is the reason that I need the other two variances. I need it because these spaces are considered a commercial parking garage, as that term is defined in 43886, and they count for GFA based on the definition of GFA. But of course, the size of the building and the garage is not changing.
Great. So how many levels of parking do you have there?
5, I believe.
So how many are going to be for commercial, the first 2 floors, and?
It's not 2 full floors, no. It's a very, very large site. There are 34 commercial spaces now, and this will take up the balance. Well, maybe you're right, it might be the balance of the first floor.
And I take it, because I know when you first applied for the project, that committee, with I think before the other panel or previous panel, you know, people, it was supposed to be, how many parking spots? Like 500 or something?
Initially, we required 522, so, which was basically 0.6 per unit, and we're now previously approved at 250, which is 0.3 per unit, and we're seeking to go to from 0.3 to 0.27.
Right, and I take it that the condominium declaration had the provision to permit the developer to change and put in a commercial, because if you bought when there was no commercial, and I say, hold it, now we're going to have a big commercial
No, it did.
lot.
Notice was given because at the time, as I said, when we came to you last time, we didn't know exactly how many we would need. We were guessing, and we guessed conservatively.
Right.
But the condo docs contemplated moving more over, yeah.
Because having commercial parking, let's say after a Blue Jays game, if a lot of people are parking down and they're all lined up to come out, it is a bit of an issue, but they're permitted to do this.
They are permitted to do that. And this doesn't alter the visitor parking for the residents in the building. They have their own exclusive visitor parking area.
So that's not changed.
So this is just extra commercial parking.
Yeah. Right. And obviously condos are entitled to charge for visitor parking should they wish.
Yes, they are in the zoning in the former city of Toronto. Yes, condominiums. But this again, these aren't the visitor parking spaces.
Right.
These are on top of that.
Off from the resi.
They may also be used by the hotel in the building, or by the museum in the building, or by anybody going to a restaurant in the neighborhood.
Okay, thank you.
Any further questions, or do we have a motion?
Okay, if no one else has any questions, I'm prepared to make a motion to approve the application. Obviously, this is reflective of the changing parking situation in Toronto and the reduction in residential parking, especially as buildings and units get smaller with bachelor units. People probably don't want or have cars. And this is especially when the building's already been built and the parking spots have already been put in, a way of using those to the benefit of the general public and having a commercial parking lot. So I would move, I don't believe there's any conditions.
No, I'm going to second your motion.
All in favor? You have your approval. Thank you. Number 33, 492 Eastern Avenue. Purpose of this application is to convert the basement of the 2-story detached dwelling into a dwelling unit and to construct 2 additional stories with west side balconies and an enlarged rear ground floor deck, increasing the number of dwelling units to 4. And we have before us material submitted by the applicant, a report from conservation authorities, support from 490 Eastern Avenue, and 5 form letters in support, and opposition from 490 Eastern Avenue as well. Yes.
Good afternoon, Mr. Chair and committee members. My name is Adam Brander. I am the agent and the architect for the proposal at 492 Eastern. I just wanted to make a note that the opposition that was filed was previously turned to support of the application, and that's on the file as well.
So the opposition came in and then it was converted to support?
Yeah, there was further understanding and communication.
All right, thank you.
You have both adjacent neighbors are in support. Right?
Yeah.
Right.
So I'm here seeking relief for 8 variances in the citywide bylaw, as well as 7 related duplicates from the Toronto one. As mentioned, there's unanimous support garnered for the application from the adjacent and nearby neighbors, which is most positive and highly favorable. We have a map to capture this that's up on the board. Support is in the green surrounding the property, and the gray area around that represents no opposition. A research package from the area compiled recent applications for these same variances that were equal or greater in magnitude for side yard setback and their duplicates. Maintaining these rather than proposing little odd jogs enhances the built form and streetscape, and all immediate neighbors at sides and rear support this approach. In looking at the nature of the other variances, it's evident that their necessity is predominantly due to a compromised site that's atypically landlocked and cut short at the rear by a perpendicular lot. Parking, for example, is not possible at this property because of this, where this can at times be a concern from planning. In other locations, they had no concerns here. On-street parking confirmed an abundance of over 300 available street parking permits in the area. And further to this, while parking availability satisfies the need, it emphasized that walkability in the area itself and proximity to transit a block away at Queen are preferred alternatives with lower impact on the shared infrastructure and environment. Yes, the new front wall of the building constitutes being altered and changing its appearance, but it's an improvement for the better. We're actually situating the front wall aligning with the neighbor's front yard averaging, improving the fabric of the collective urban form while adhering to zoning principles. Average interior floor area per dwelling of 59.84 is less than the prescribed 65.0 meters squared. It's minor in nature, and there are past precedents for more substantial reductions in average area down to 44.16 meters squared that we found that were also considered minor. With respect to height, the building conforms with the 12-meter maximum height. There is, however, a portion of the sidewalls at mid-depth of the building that exceeds its prescribed height to meet the conforming roof. This wall portion is recessed substantially from both the front and rear building, eliminating visibility from the streets and surrounding grade level, offering no negative impact by its form. And in a preliminary review with City of Toronto planning staff, we inquired specifically if there was any concern with the density variance, to which they responded no. This supported our understanding that this was a reasonable variance request, given there are other properties in the area with greater densities up to 1.98 times the lot size, and the height and numerics here of the variance due to the backyard cut short, and the site location. We have a map illustrating this condition. So the building sits on the fringe of a residential peninsula, kind of transitioning to higher and diverse densities on 3 sides. It transitions to a 2.0 density on the east and the south, and a 3.0 to the west. And these include commercial, office, and industrial uses found along Eastern Avenue. And we find the higher density mixed-use description would characterize the siting in urban context perhaps more aptly than the qualities generally relating to a residential neighborhood. In review, are the variances requested minor? Yes, they're supported by past precedent that we have here if you'd like to see. Is the general intent of the zoning maintained? Yes, the proposed built form maintains the general intent of the bylaws. Is the OP maintained? Yes, a gentle increase in density close to the downtown core and transit nodes is supportive. And for desirability and appropriateness, yes, given the use of the building, maintained as a residential use in a residential zone, while participating in the diverse and higher density urban conditions and built form along a major street such as Eastern Avenue would seem a harmonious marriage for the site, desirable and appropriate. Thanks.
I have a question. Can I ask a question?
Sure.
The two houses, their houses, I take it, at 490, set of semis. On the other side, there's a one-story concrete block building, 494. Is that something that's going to be redeveloped in the future? What is that right now?
I believe so. It's an office use currently.
Office use? You don't know what? There's nothing ongoing, like in terms of what's going to be on that site, or?
Not that
You
I've
don't know?
located.
Okay. Thank you.
Mr. Browner, how is the front yard dealt with in this? As I see on your main floor plan, there's one entrance, and then there's a stairway that leads to one unit, and then there's another stairway that goes down. So you have an access to the basement, but it's within the building. What actually happens in the front yard?
Well, originally, there was a previous iteration went to planning, and this is really to do with egress and safe exiting for the units. We had a front yard basement walkout.
And you've incorporated it within the building?
Which they preferred, yeah.
Okay. And could you provide parking? You couldn't, or there's no space between the front wall of the building and the street line?
Correct.
To provide parking, right? And otherwise, you'd have to take the building down?
Yeah.
Okay. Thanks.
And I just have one question for you with respect to, it looks like there's a real large building across the street at 495. I'm just wondering, because you have a large front terrace on the top floor. Yeah. I'm just wondering, it doesn't show up as a variance for being oversized or anything like that. And I guess there's no overlook because there's this, you're not looking out on residential, you're looking out on this large building across the street.
Yeah.
Is that something that's going to be redeveloped, 495?
Not to my knowledge.
What is that building? Is it
Isn't that like the old, is that the Weston Bread?
The Western Bread's to the
It's
west.
almost the whole block. There's one large building, and then there's another building on the east.
That's not Western, that's.
I know the one kitty cornered is a storage facility that's being built.
Yeah, 495 and 493, I guess.
So on the south side of
one large building on the south side of the street. So I'm just trying to say there's no problem with overlooking that building, as opposed to if there was something else there. Yeah, that looked.
Is that the historic building that the city uses? The large building on the opposite side of the road, on the south side of Eastern?
No, not that I'm aware of. There's the Weston Bakery to the west.
Yeah.
It's a different one that's just on their side of Logan.
It's on Logan, yeah.
It's getting redeveloped.
I'm curious if that's not a variance, that terrace. Is there a matching one? It says, it's shown on your plan, A10 as a terrace.
Yeah.
At the front.
Yeah, I don't know why.
Is that an amenity space for all of just one of the tenants, or all of them?
No, it's just one of the units. And the terrace, the smaller terraces are at the front are used as
Parapet, and it's actually smaller, or?
Yeah, it's set back from the street.
Terraces on both sides, right? There's one at the back and one at the front.
Yeah,
the one at the back's got a...
One at the back is just a green roof.
Okay, but you can go out on it.
We're not putting access there, no.
The one at the back doesn't have a label saying terrace, only the one in the front.
Only the one at the front. And the question that's been raised is, if the property across the street is residential now, which it isn't, or it becomes residential in the future, there's a privacy concern. So it would be useful to know what that building's used for.
Right. I would suspect at the higher density across the street that it is now, the overlook might be in the other direction towards the property that's smaller.
So what did you say the purple is, the density is for?
It's 2.0 to the south and 3.0 to the west currently in zone industrial.
1.7, okay. I'm just wondering how you get access to that terrace, top floor.
There's a stair in the upper unit with a small mezzanine space.
I see, okay. So you can walk through the mezzanine and exit out on the terrace. But you're saying that's not all terrace, there's a sort of a parapet and there's this
setback.
Smaller.
Yeah.
Yeah, what is that space for?
Do we have a motion?
So I'm not clear then. Can you refer on drawing A5? Mr. Clark's question. The thing that is labeled terrace is the entire roof on that side of the building. Is that, or is, our drawings are very faint, so perhaps we're not seeing everything. Or is the terrace just to where the dotted line goes?
No, the dotted line is just a roof overhang, but the terrace extends further. There was actually no variance required, but the railing can be drawn on inset from the parapet.
And how high is the parapet? Is it's like a railing height?
It's minor. It's just less than 12 inches.
Oh, okay. So you need a railing as well.
Yeah.
Are there any further questions, or do we have a motion?
Well, we have TRCA as no objection. Both adjacent neighbors are in support. We're on the, as the agent stated, we're on the cusp or the boundary of a large industrial area. So I would move approval of the application. I don't believe with any conditions.
Would you tie it to plans? My only concern with this, well, I mean, there was a few, but I'm satisfied with what you've presented as the exterior sidewall height. And you look at it, it seems a lot. It seems quite a large variance. You're asking for 11.99 meters, but I think that is softened by the fact that it's pulled back. It's not a full 4 stories. When you read it, it's like, wow, 4 stories in height. I don't know.
Well, it would have the floor. I guess I would agree to tie it to plans.
I don't know, maybe
And it's,
perhaps then it's mitigated by the fact that it's tied to the.
Well, they do have a height
floor space.
variance if they wanted to go, they have a floor space index. If they tried to fill in the whole 4th floor, then I guess that would trigger another variance.
Unless they decide to take it from the base. Is part of the basement included in the GFA?
Yeah, it does get included on the 4-unit building.
Decided not to develop the basement into residential, you could plop
Okay,
that
so-
up.
It's only in the former bylaw, but
In the
Okay, so-
former.
yeah.
Okay.
So would you have any objection if we tied it to the plans to be built substantially in accordance with the plans on file? I don't know which, if all of them, or if we just make reference to
Side one of the
this.
sidewalls? If that's overkill, then tell me. But
it's a sidewall condition is fine.
If you were going to do that, Mr. Clark, I would also include the ground floor plan, because I think that's a particularly admirable solution for access to the basement, and it was negotiated with planning.
So it's drawing A2?
Shows on A2, yes.
So which would be the other ones? Do we need A1?
Tie them to all the plans.
That's probably the easiest.
Yeah.
You know, you need A10 to show the. So just to give some guidance, if we're going to tie it to plans, which plans are we tying it to?
I suggest all of
Okay. And they're all date stamped.
them. I think if you
Yeah,
start
that'd be
piecing them
difficult,
off.
though,
Yeah.
If we attached to floor plans. 'Cause then they would have to comply with everything at the actual floor plan as
It
is.
says it's substantially in accordance with, and the
Yeah,
one
and
I
it's-
recommend it is a floor plan.
Is that?
Yeah, because
For a basement.
this gentleman has has responded to a planning's concern about access to the basement, and he's done it in a very nice way, and he's incorporated the entrance into the building. I think that is admirable and should be part of the approval.
So what drawings? I don't want to do, if it's overkill and then he's going to run into problems, if we don't have to tie it to certain plans, and experience probably best we don't. So to protect what Ms. Valentini has suggested as a friendly amendment, that they don't go and build across the whole a full fourth floor, how do we ensure that?
A8, would A8 do it?
We want A2, which is the ground floor plan, correct?
1A1.
A5 and A9, I would argue, that because that shows the fourth floor.
That's fine.
Responding to.
Yeah,
Yep.
and it also shows that there's no terrace on the others on the back end.
Yeah.
Sure, done.
Yeah.
A2 or A1?
What's the
Carl?
5? Oh, I see.
Yeah,
Right.
the fourth floor.
I had A2, A5, and A9.
Why A5? Because of the terrace?
Yeah, it shows what
Yeah,
you're doing.
and it shows you're not doing a full fourth
It
floor.
shows that this is the building and there's terrace there and nothing there.
Okay.
And A9 shows the side elevation, the west elevation.
Would that be okay, Mr. Brander?
What about the east elevation?
Yes.
No.
Okay.
So,
Need a
Is
seconder
that
for
your
that motion? Yeah.
I'll second it.
all in favor? You have your approval.
Thank you.
A2, A5, and A8.
Number 34, 28 Bathurst Street.
A2. A2, A5, and that.
Purpose is to construct a mixed-use shipping container development as an interim use. And we have material submitted by the applicant, a report from planning, and correspondence and concern from the Niagara neighborhood now. We have a letter from Councillor Layton in support. I'm not sure. Overwhelming positive feedback. He's doubly supportive of the brewery. Okay. Your name, sir?
Thank you, Mr. Chair, members of the committee. My name is Eldon Theodore with MHBC Planning. I'm here on behalf...
Sorry to interrupt. I have a concern that I don't understand how the shipping containers are being used. The reference in your submission is it's to create an experience of curated discovery.
Correct.
Could you clarify exactly what that is?
Sure, and perhaps what would best help is we have a rendering of the proposal of what that would look like. I'm just going to put that up right now. So what it is shipping containers that have been constructed to be utilized for a combination of uses that include showroom space for display of products, incubator space for startup businesses, restaurant uses, retail uses, and at the end is a craft brewery as part of the overall experience. And you can see along the rail tracks to the south there's a landscaped open space area as part of the overall experience for people to walk around the site and to visit the different shipping container tenants within the site.
Is the brewery within one of the shipping containers?
Yes, it is constructed through a collection of shipping containers. Pardon?
All those blocks are shipping containers.
That's correct.
Nice.
So that's generally what the proposal is, and to also help the committee, we've also provided some other examples around the world of what other people have done with the shipping containers, and we'll just cycle through those so you can see those examples. But what I'll explain is that the plan for these lands for the city for the long term is to become a park, and these are the city's lands. And my client, Stack Properties Limited, and Matt Rubinoff is here today representing that tenant. He is in a contract with the city to operate this development. and the city supports the activation of these lands until such times the park is ready to proceed. So really, what the shipping containers do is they provide an interim use that can come in easily and could be removed easily when the park is ready to proceed.
So in the meantime, like there is a shipping container, I wouldn't call it a development, but there's shipping containers along Dundas at Bathurst Street.
That's correct, sir.
But there's no building surrounding it. I assume this isn't much of a building that you have, just enough to contain the containers.
Well, they have to be built to building code standard because they have to be occupiable and they have to be heated. But because of their construction, they're a lot easier to retrofit into a habitable space. So that's what makes them nimble. You can bring them on site quickly.
What about plumbing?
Plumbing is a temporary connection that we do to the city's system, and this site has already achieved site plan approval and notice of approval conditions through city planning. That includes the connection of services on it. I believe it meets the intent of both the official plan and zoning, because the proposed uses that are on this site are contemplated. What we're seeking is flexibility on the site with respect to the restaurant component, the retail component, and the patio accessory to restaurant component. It's permitted, this property is split zoned, so it is permitted on the eastern portion of the property, but the western portion, that is where the restriction lies with respect to those particular uses. The brewery is permitted as a right on the western portion, and that's part of the connection relative to the brewery. We want to be able to institute a craft brewery consistent with other type of craft breweries you see in the city, you know, such as Trinity Bellwoods or Steam Whistle, where there's a component of experience in which you can come in, you can have a tour, you can walk through, and at the end there's an opportunity to sample. It's a sampling component and the experiential component that requires those variances in order to allow for that extension of the use. And the city's already going through a comprehensive amendment to their bylaw for industrial and commercial zones to allow for this universally across the city's former bylaw. So what we're trying to do is really advance this forward, knowing that this is coming into effect, even though we know this is for a temporary use, you know, up to 5 years, which is what city planning staff have recommended on the site.
So, Mr. Theodore, variance number 1, you asked for a retail store. Do you want a retail store or retail stores?
A retail store is the use, but not necessarily that it's going.
I'm not changing anything. I just.
And I can say that we worked very closely with the zoning examiner to pin down what exactly we needed in order to permit this. So I'm comfortable with the language as it's set, sir.
The showrooms and so forth that you were talking about. Showrooms would also allow you to buy product that you had on display, right?
Yes and no.
You'd want that flexibility.
Yeah, well, I mean, we would want that flexibility to.
Wording would allow that.
It would, sir.
Yeah, fine.
So this variance number 1 doesn't relate just to the brewery, does it? It relates to a variety of retail stores on the site.
It relates to a variety, but our principle at this point is, and our main interest and driver at this point is for the craft brewery, because we know that that's a connected component of, you know, bottle sales as people can fill up, but also the sampling component as well.
Okay. All right. Any further questions?
You've seen the planning department's recommendation about time limit?
I have, sir, and we have no objections to that condition. It's a fair condition.
Okay.
And it is the city's lands, so.
They have this agent, this company coming in that they've leased it to.
That's correct. The Stack Properties Limited has a lease with the City of Toronto.
What craft brewery's going in?
Pardon?
We know which craft brewery?
Not at this time, and even if I did know, I wouldn't be allowed to reveal.
Okay.
But I do know it's not going to be a big like the big Labatt facility you see on the 401. This is really a Focus Brewing that would be an extension of that type of brewery, something that we see local within the city.
Okay.
Mr. Chairman, unless anyone else has questions, I'd like to move approval of the application. This is a worldwide approach to using the lands temporarily, and I think a very clever one. I think with the condition that the planning department has recommended that there be a time limit of 5 years so that the approval would expire on June the 13th, 2023. With that condition, I think this is quite an appropriate variance approval, and it clearly meets the intent and purpose of the official plan and the zoning bylaw and the other tests for variance.
I'll second that motion.
All in favor? You have your approval, sir. Thank you.
Thank you very much.
Number 35, 825 Coxwell Avenue. Purpose of this application is to alter the redevelopment plan for Michael Guerin Hospital, approved under Site-Specific Bylaw 961-2011, by permitting additions to the building which will be located beyond the allowed development area, and by permitting some elements of construction to exceed the maximum permitted height. The hospital redevelopment will be comprised of demolition of portions of the existing hospital and construction of an 8-story patient care tower on the existing parking lot fronting Salmon Avenue. We have before us materials submitted by the applicant and correspondence from planning. Yes, sir.
Good afternoon. I'm Matthew Smith. I'm a principal with Dimension Architects. I'm acting agent and lead architect for the redevelopment of Michael Guerin Hospital, which is being delivered under Infrastructure Ontario's design build finance model. So we're here today, and sorry, I'm accompanied by Kelly Henderson, who's a senior project manager with the hospital, and by Rob Bradley, who's a project manager for Elliston. We're seeking 3 variances to the site-specific bylaw that reflect both subtle changes to the programmatic requirements of the hospital in the intervening years between 2011 and the present, and also to deal with some technical issues that are specific to our design solution. So the first variance has to do with portions of our building envelope that don't fit within the shrink-wrapped zoning plan that was provided in the site-specific bylaw. We're not increasing the area of the project at all, and actually the majority of the overages are to the north, where, and by virtue of the fact that we've actually, in sensitivity to the Salmon Street neighbors, pushed the building further to the north. So we have some areas of the building that are outside the zoning envelope, primarily to the north. The second is a requirement or a limitation on projections that are specific to outdoor recreation areas. We are permitted 3 meters. We're seeking a variance to extend that to 5 meters in order to deal with some specific safety requirements related to mental health patients who will be using an outdoor terrace located on the 5th floor. And then the final variance that we're seeking has to do with the mechanical equipment projection limitations. The reality is that by the time we put in place diesel generator stack and some other exhaust stacks, we simply can't stick within the 5-minute limitation, and are seeking a variance to allow us to install those things in a safe manner.
My only question was understanding what is actually being taken down. The site plan, which is A010, what you've labeled as public hospital, that's basically the expansion, right?
Everything that's toned is the
Salmon Avenue frontage and extending. Is there anything on the Coxwell frontage that's being removed?
Well, if you're familiar, and I'm sorry I don't have photos.
I am.
With me.
I know.
Of Toronto East General, the majority of the oldest parts of the hospital are being removed. So the sort of iconic boomerang shape.
So this is coming off,
building,
right?
That's all coming off.
Okay.
So there's a single piece of that sort of old fabric, which is called the D wing, which was actually the first
That's right. So the first portion of the hospital remains.
Okay, but all of that's coming up.
All of that comes down.
Okay, thanks. That answers my question. Yeah, thanks. That's all I wanted to know.
Okay.
Number 36, 113 Borden Street. Purpose of this application is to alter the existing townhouse by constructing a third-story addition, and we have before us in this application material submitted by the applicant and opposition from 115 Borden Street. Nobody's here in opposition, right?
Sarah Ifra, agent for the applicant. We're adding a third story to this existing townhouse dwelling. In terms of the variances, number 1 and number 2 are similar variances, and we're talking about 4-6 inches in terms of where that height is measured. Now, it also should be noted that that's on the 3rd floor, which is set back considerably from both the neighbors' 2nd floor homes. Number 3 is the floor space index. So we're talking about 17 square meters. And again, contained on the 3rd, which is set considerably further back. Number 4 is the distance between the main walls. This is an existing condition. There are no changes. We are not adding windows on those sides, so we're not making anything worse. It's just, I guess, making an existing condition allowable. Number 1 under section 6.3 is, again, the floor area. So we're talking, the numbers differ slightly here according to the zoning examiner. So again, we're at about 15 to 16 square meters. Number 2 is the length of the townhouse. Again, that's an existing condition. We're not going beyond that. So there's no changes there, but I guess allowing the existing condition to occur. And then the side lot line, again, is an existing condition that we don't have any changes to. We're simply going up over the 2nd floor, not even including the 2nd story little bump out that it has there at the rear. But we're not going outside those limitations.
Any questions? We have a motion.
This is two-story buildings on either side.
They're both two-story dwellings, although number 115 does have the same type of roof as, or the same height of roof that we're proposing.
Yeah, I see this on the.
You can see it on the.
Oh, no.
I do have some photos.
Do you want to? Okay. So it's not like a uniform block of townhomes that all look the same?
No, so I can show you again next to these ones here. I can do that. So this one is ours.
Right.
That one's the next door, then that one happens.
So, but it's attached to this one here as well?
Yes, yes.
Okay, that's what I thought, that it wasn't
So
uniform,
is
but I was.
this 115? Is this the neighbor at 115?
No, 115 is actually.
Oh, it's there, okay.
So this is void in here, is that correct, this space?
No, the roof slopes back there.
So
but-
this is a sloped roof, and then you're projecting a dormer out at the front?
That's right, that's right.
Okay, and this roof continues here?
Exactly.
It continues across there?
Yeah. And slopes
Oh,
back.
okay, there it is, there. Yeah, okay.
Thank you. So it matches the height. So just to clarify again, it matches the height at 115?
Yes.
And it actually extends the roof pitch. The roof, the sloped roof is across this one.
Oh, it's
Has a
gonna match
gable,
it?
And that
It-
one has a, yeah, and that has a dormer.
I see.
So there's two projections of, it will look like a single roof sloped like this.
Yes.
This one will have a pitch.
Triangular, yes.
and this will have a dormer.
Dormer, okay. Interesting.
Your porch continues on the other side, is that correct?
Onto 111.
Yeah.
The front porch we're talking about,
Yes,
right? Yes,
yeah.
yes.
You have a motion?
Anybody have any questions? I'd like to bring a motion forward for approval. I think that in this case, you are adding a third story, even though there's 2 stories next door, but I'm satisfied you're integrating it into the house at 115. Your variance for floor space index is, as you said, about 17 meters square over. You're not, in my view, that's minor in nature. So my motion is for approval of the application. I think in my view, it meets the 4 tests for a variance.
All in favor? You have your approval. Number 3793 Galley Avenue. Purpose of this application is to alter the existing 2-story detached dwelling by constructing a 3rd floor addition. We have materials submitted by the applicant, correspondence in support, and including an 8 form letters. This is a very straightforward application. Do we have any questions, or do we have a motion?
No questions for me.
Perhaps you could give us your name before we approve your application.
Hi, my name is Carolyn Morissette, and I'm one of the owners and the applicant for 93 Galley Avenue.
Thank you. All right, do we have a motion?
I'll move approval of the application with no conditions.
I'll second it.
All in favor? You have your approval.
Thank you very much.
Mr. Chairman, I wonder if we might compliment the applicant. This is a really comprehensive submission, very easy to understand.
No questions.
Steve provides excellent data. Enjoyed Thank you very much.
See, they're all that well together, just breezing
Oh, it
through the
would
whole
be,
thing.
yeah.
We're like, that's perfect.
Now we go back to number 31.
Oh, right.
Are the parties here? Okay.
Yeah, Mr. Chairman, the neighbor was a tenant who was not able to stay. Excuse me, I explained the application and assured him that I would convey his concerns to the committee and outline what the issues were.
All right.
My name is David Brown. I'm the authorized agent for the owner of the property.
Yes, okay, but let me introduce the application first. Purpose of the application is to alter the existing 2-story. Now, we have row house here. I've been advised it's a mixed-use building. Is that correct?
It is, Mr. Chairman.
Okay, so the purpose is to alter the existing 2-story mixed-use building by constructing a 3rd floor addition and a rear 3-story addition. We have before us material submitted by the applicant and a report from planning. So you say the opposition just needed an explanation and has left?
Yes, there's a little...
Your client or a tenant of an adjacent building?
Tenant of the adjoining building to the south, which is a 3-story structure.
Okay.
He's the tenant in that building on the 3rd floor.
I see.
He has a window that faces over the subject property, and we're proposing to construct a 3rd floor onto an existing 2-story building with an addition at the rear, and that was going to impact on his window. I had a conversation with him about building codes and zoning bylaws and hazard rights and all of those good things, and suggested to him that my tenant, or my client, the owner of the property, and his landlord are going to be having a discussion with respect to how that issue of the window will be resolved. There is a solution. It's a skylight. It's going to require the 2 parties to sit down and have that conversation. I suggested to him that this would be an appropriate forum to raise that concern. However, it was my submission and comments to him that I don't believe the committee was really in a position to do much about that, and that it was more building code than it was zoning bylaw, and it was an issue that we would be able to resolve.
So it's not a variance for setbacks, with openings, that kind of thing?
Correct.
And the skylight is on his property or your
No,
property?
the window is his window on his building.
Say is a solution.
Would be the solution. It's
On your property.
on his property, on his building, that would have to be, to replace the window so he gets his light and the ventilation into that room. And that was our conversation. He did indicate to me that he was going to stay and share these concerns with the committee, but he had to get back to work, and I conveyed that I would raise those issues so the committee was aware, but also that I told him what I'd be telling you, and I just have that it was an issue that would be dealt with by the landlord and my client to resolve it, because there is no relief being sought with respect to the third floor. It's permitted as of right, and if we were to shave approximately a meter off the length of the building, if I took 2.5 meters off the length of the building, I'd meet that rear yard setback requirement, comply with the angular plane, and the only issue would be height. And for 9 centimeters, we would probably figure out how to resolve that. The reason we are asking for the variance in height for the 9 centimeters is because I'm here with the angular plane, and to take the 9 centimeters or the 4 inches out of the building height just didn't seem to be.
But to be clear, the solution that you suggested might potentially solve the problem isn't something that you can implement anyway, because it's not on your property. So the solution is a solution by the owner of his building to provide a skylight in lieu of a window.
Right. That would be correct.
Okay.
And your client's going to pay for it, I guess.
Well, that's a conversation that those two gentlemen are going to have, but I'm going to put them together to have that conversation. Yeah.
So his concern is about light with the window? Is that the issue?
He's the tenant. He's on the 3rd floor. He's got a north-facing window that looks over our property. I explained to him the application and his issue. Quite frankly, he said he doesn't care about anything else except the fact that what he reads will be a wall will be built on the 3rd floor that will block his window, and he's right.
Oh, it'll actually block the window.
The wall would go right
Solid.
along there. So.
Okay, I got it now.
So the window would be closed.
Yeah.
The wall, yeah, the window could remain, but it won't.
There'd be nothing there.
It'd be non-functional. I mean, you'd be looking at a brick wall or a block wall.
There's a setback. I thought there was.
No.
It's a row. It's a row. Yeah. Okay. I got it now.
Have you seen the recommended conditions from planning?
I have. I've been working with planning staff, and I can appreciate their concern that the variance as is framed would allow us to do something a little more than what we're proposing. By tying it to the plans as submitted, as the conditions have set out, would ensure that what we've proposed is what gets billed and approved, and we're satisfied with that.
Okay. All right. Does anyone have any further questions relating to the variances? Or can we have a motion? You've seen the staff report conditions?
I have, Mr. Chairman.
They're okay?
And they're acceptable.
All right.
If there's no other questions, I'll move approval of the application subject to the 3 planning conditions.
Seconder?
I'll second it.
All in favor? You have your approval, sir. Thank you.
Thank you very much. Have a good afternoon.
Nope, 38. We're done. We're done the two.
We're at the 4 o'clock agenda?
It's 4 o'clock.
4:05.
All right. Number 38, 29 and 30 Glen Manor Drive. Is the applicant here? Is there any opposition to this application? No. Good. All right. The purpose of this application is to obtain the consent to sever the property into 2 residential lots. There's no variances being requested.
That's correct.
Okay. So we have before us material submitted by the applicant, email correspondence from the right-of-way management, a staff report from engineering, and I believe we also received today a letter from Bell Canada with respect to easements. Have you received that?
I've seen 2 of the 3. I haven't seen the right-of-way management one. I don't recall seeing that.
Somebody...
I don't remember right-of-way.
Engineering.
There's nothing online.
Planning consent.
Have you got the one from engineering?
I have the engineering comments, yes.
You've got the one from Bell?
Yes.
So, Mr. Director, I guess this is just, I've seen these applications before. It's being done for state purposes.
It's, yes,
There's no construction plan?
there's no construction, no changes proposed. My client, who owns the 2 units in one of the buildings at number 30, has said, I'd really want to own the building and the land of my own building, and that's the purpose of the application. And the owners have all agreed and can sign the application, and that's why we're here. It's pretty straightforward.
Right now, there's more than one name on the deed, so they want to make it singular deed.
He just wants to have title to his own property and...
By himself.
By himself.
Yep.
And that was the trigger of the application.
Yeah. Okay. Do we have any further questions?
I'd like to speak to the comments. I don't know what the committee's intentions are. The condition proposed by engineering is straightforward. It's a standard condition dealing with municipal numbering. I don't have an issue with that. I didn't know what your intention was with the letter from Bell Canada. I found the letter quite strange. There's a bell line running in the backyard along the property line. I don't know where it is. That's right, along the back property, and they're looking for an easement to accommodate it. I don't know where it is, and I don't know the nature of the easement, and nor do they, because they're suggesting it should be something that's 1.5 meters on either side of this line, and our surveyor didn't pick it up. I don't know where it is. I don't know the effect of it, and I don't know ultimately what might happen to my client's property if they want to build a shed in the back or do something in the backyard where that easement might be located. I do note at the end of their letter, they're suggesting that the owner's solicitor should be contacted, and maybe we can have a discussion with Bell, but I would not feel comfortable asking for or supporting for my client a condition that there be an easement to satisfy Bell Canada.
There's nothing being done here.
There's nothing physically being done here. We're not building anything.
So you haven't identified a Bell telephone easement on the present, on the property?
Well, there isn't an easement now. I don't know where the Bell line is on the property, so I can't figure out if I were going to do an easement 1.5 meters on either side of the line where that would be. As I said, I just saw the letter literally this morning, and...
Where's the easement? You said you know where the easement is.
Well, they had a 2-page letter, and they were showing in yellow a proposal for an easement along the back property line, but the exact location we don't know, because it's subject to where the line is. I don't know where the phone line is in the backyard of these properties. Well, remember, it's a bell line running along the back of a lot of properties on 2 streets. And I guess if they get a chance to get an easement, they get it, but I don't know how they get to it. They can't cross my client's property to get to it, so I don't know really even what the purpose of the easement is. Again, I ask that you not impose that as a condition.
So I mean, we could say this is a technical severance with respect to title only, and refuse the Bell telephone because they don't need anything other than what they have now, but we may get ourselves in trouble, may get you in trouble.
Typically, we don't do these as conditions.
Yeah.
That's a risk I have to take, that if Bell's not happy and they want to appeal, that's my risk.
Yeah.
I just don't want it imposed.
We don't deal with the Bell telephone request at all?
Yes.
I'm happy to do that, to give you what you want. I don't know what you're going to do with Bell. But I would think they already got what they need.
It's there.
Yeah.
So
there's nothing being triggered by this.
That's right.
Severance.
That's right.
Yeah.
There's no more further questions. I would make a motion to approve the application subject to the engineering, development engineering comments, and I guess your standard conditions with respect to consents.
Second motion.
So just technically, it's not an application, it's a consent request. So, yeah. Okay, all in favor? Approved.
Thank you.
Thank you, sir.
Yeah, just
For information? Okay.
Yeah. Okay, so that's our list, I think. Pardon?
I've got one of those.
Oh, we could start
We don't get
talking
we don't get overtime either, so.
It's one of those at the back of my property apparently, and he's right, you can't get to it.